Uganda versus Edward and others.
Alright, mwina bakatuyingako amachago olwaleero ekigenda maaso right now ye court session eyokulira misango gy'Abaganda baffe Eddie Mutwe, Alex Waiswa Mufumbiro, Olivia Lutaya, Bobi Giant n'abalala abawerako nga mumanyi our political prisoners bayitirivu nnyo. These are just a few baleeteddwa mu kooti olunaku olwaleero era nga yene engeri Baganda baffe gye batuuseemu bakyali bagumu mu ngeri emu oba endala, naye nga gwe w'okimanya ekkoomera tuyinza dyagaliza mu nnondoozo balengera Eddie Mutwe omulengera yuuyaawo, Akireewo Kivumbi omulengera yuuyo, baabo Baganda baffe abamu ku bo mujjukire nti nno Bobi Giant omulengera, abamu tebamanyi na bamanya sijja kulimba Alex Waiswa omulengera yuuyo, tebalina nno musango nagumu gwe bazza nti babalina gwe bazza no baaba no.
The hearing, I'm talking phones and you still continue. Let media do their work. You raise your hand if I call your name. That's counting out. Serukuma Edwin, Lukenge Sharif, Nyansi Yasin, Awesi Tony, Waiswa Mufumbiro Alex, Madada Sauda, heightened, Lutaya Olivia, Tobe Ashraf, Muwonge Richard. Semata Dennis. Chibi Dennis, Tarega Majid, Sengo Yasin, Katopol, Siwa Robert, Baluku Farouk, Senga Washapi,
and someone just
present. The one I've just read. So ask for the latest time.
Because we are linked to the Facebook, that's why the one that's stops at 8:20 and
bade nkyakugamba tebalina no musango nagumu gwe baakola nti oba waliwo omusango gwe baakola naye simply because Museveni ayagala okulaga nti wamaanyi nnyo whoever comes out to speak about the challenges we face on a daily basis oyo aba alina kusibira mu kkomera naye kikwasa obusungu bannakigwanyizi bali mu kukozesa baganda baffe bano the political prisoners for their own selfish motives. Mwalabye ensibambi gyo be bamu ku be bafrontinze okubeera nga bubaperereza his excellence Kyagulanyi nti vaayo gy'oli gye weekukumye jangu olw'ensonga simanyi embiranyi gy'olina ne gavumenti tusobola kugigonjoola nga toliiwo bw'ate simanyi ne ba political prisoners tugenda kubata. Is it a condition in the first place? Which crime did they commit? Because bano baganda ffe tebalina musango nagumu gwe baakola. Tebalina musango nagumu gwe baakola. Ate nga si be bano bokka bayitirivu nnyo. You remember the first ever national interplatform press conference immediately after the elections bajja ne batubuulira nga baali ba profiling over 3,000 detainees, some in gazetted detention centers and some in non-gazetted. And when I talk about non-gazetted, that means they are held in a communicado, allowed to see them, whether you're a family member, a friend, a lawyer, and all that kind of thing. In a similar fashion, everybody basibyemu our deputy presidents, that's Jolly Jacqueline Tukamushaba of Western Uganda, as well as Mama Lina Zedriga of Northern Uganda. Good news for them, they are temporarily free. They were given bail recently. Nenga bayitirivu nnyo baganda ffe bakyali mu makomera. Naye nga of course akaliro kano koolaba okubeera nga aba regime propagandists bavaayo ne babeera nga bayogera biboogera nga walabye ensibambi wavaayo n'awoza musimanyi ba political prisoners kinana simanyi bagenda bata simanyi bano bagenda. No, it's because of the international pressure. Last time I told you His Excellency Kyagulanyi is internationalizing this struggle very well era ng'ensonga azikwasaganyiza bulungi. Kati akalira akava side eyo mukyajjukira resolution EU gye yayisa ng'eragira regime eno bayimbula abasibe n'abo batamanyiddwa gye bali babeerenga their whereabouts zibeera disclosed. So kyobalaba nga once in a while olaba nga bataddeyo ono ne bataayo ono. So let's hope these our comrades will also get their freedom, though we need to keep fighting to gena maaso nga tubanja their freedom because they did not commit any single crime whatsoever. Nkwebaza yonna gy'osinzidde okubeera nga otweyungako wano ku JB Muwonge gera maaso nga this live broadcast ogisharelingako ne munno agisharelingeko ne munne so that the entire country gets to know the current situation regarding the fate of our comrades Eddie Mutwe, Alex Waiswa, Olivia Lutaya, Sauda Madad, Achirewo Chivumbi n'abalala bayitirivu nnyo.
That is Madada Sauda, Kaida Doreen, and Lutaya Olivia. Let me hear from the state.
All the 21 accused persons are in court. Your Honor, we are hearing line that is A9, Sauda Madada, A10, Haida Doreen, and A11, Lutaya Olivia. here online via video Zoom. Whereas the rest are physically in court. They are represented by a team of lawyers. If you allow me, Your Honor, they will introduce themselves.
Yes, Cynthia, can you introduce yourself?
Your Honor, this is Senator from together with Kato Musime, Kapui Musime, Serum Kuma Farouk, Kenneth Gideon Numbi,
Can you just first get your name?
Your Honor, and also Jewel Senwe. Your Honor, my colleague has an issue with the charge sheet. Wants to submit or something.
It's Kato Tumsine for the
Your Honor, before my colleague takes, I've just speak to the colleague, and is
Juliet.
Juliet.
It's for the record Kato Tumsine, Your Worship. But before I proceed, 8-8 has been dated to me that he has the services, so the trade is called now. Your Worship, our issue is on the charge sheet regarding the number of accused persons read on this page. And the last time of appearance on 23rd of January 2026, my colleague made a prayer to this court which was granted, barring the prosecution from any amendment to this statute. Your Worship, as of 29 January 821 was added on the same section via an amendment. That's a clear violation of the court order.
Now, I'm going to clarify that. There was no violation. The state approached, and this person was already in the process of that day, the investigations. So he had already been. So I allowed that should be the last person. And as you can see, from then there has not been any other additions. It was a prayer that was already in process. So I had it known that was already in the process of being brought. That is but we have him, he took plea according to the law, and he's present and alive. So, and he was ready to his rights then, as the record shall show. But that was just an exception. And from then, it is clear that there will be no other additions from the state.
Your Worship, the reason I made that before this court, I want this court to also make it clear that that was the last one.
And I'm saying it again, that is the last, because as you can look at the date, today is the 27th of February. That person was brought on?
29.
Yes. So there has not been any further additions. Yes. Yes. So we are making it clear that if there is any other person, a new charge sheet should be presented so that we can handle the 21 persons.
Your Honor, we pray that prosecution is not locked out really when, especially where the prosecution has the liberty, Your Honor, to amend as and when, Your Honor, circumstances permit. Your Honor, I will leave it at that, but I pray
I
that.
want to clarify that I don't want to go back to what I said then. I don't want us to get that discussion back on the floor. For reasons being that these persons have had them from the 14th of August 2025, I cannot continue allowing amendments because it is unfair to this other person. Because you can amend until 2040. If I give you the liberty to. So allow us to close that part. Amendments have been many, and also a part to the end of that, to make the justice that we deserve.
So, why the prosecution is particularly concerned
yes,
is that if the defense succeeds in putting the court in such a position, it is going to set a dangerous precedent. We pray that these persons their cases should be treated on a case like
and that's
this.
what I'm saying, that even if I am to allow, I'm saying that you can't say I'm on the defense side, it will allow, because court must start a litigation. So when do we ever start?
Your Honor, we're ready to proceed with the hearing, but
With amendments, we go back to disclosure to the beginning. Because we are using the same charge sheet, we shall even bring the same witnesses back to court for cross-examination. So, in my court, I've decided that we are stopping the amendments. I have allowed several amendments. That person is putting on shades, please remove them. Let us have order. If I came with shades here, I don't know how you would welcome me. The way you want to present, the way you want me to present myself is the same way you should come. If I came in shades to attend to you, would you be okay with it? Should we try it? So let us have some little order, at least decorum for court. Then we can do other things outside. So what I'm saying is that for us to start litigation of this case, we must stop the amendments. And amendments are not even to fact, they are to addition of persons. You're not adding charges, you're adding persons, which will lead us backwards. So you can charge this person on a different charge sheet, and still the ends of justice shall be made. So it does not stop the justice from being made, just because I've stopped an addition of a person. You can open a new charge sheet and have that person prosecuted. But for now, I also
network kakutemu naye
cannot come here every single day on disclosure and amendment. Cannot happen. So today, the 27th of this month, February, we shall stop additions and amendments. We are going to start with these people and we'll see where they are ending. And I hope we do not go back to the same.
Your Honor,
So we can proceed with the business for today. For 1 week.
Your Worship, all the 21 witnesses in court and the defense counsel have introduced themselves. I'm not sure if
what one can do for us is for the official court to be comfortable in court because the way she has seated here.
Yes, she contributes.
Let me have the court orderly get a chair for council. Court orderly, help us with a chair for council. State, what business do we have today?
Your Honor, I think one or two sittings earlier, I referred to this honorable court to regulate the media. Your Honor, the reasons were given, we submitted on the same. And shared authorities, Your Honor. The defense, however, sought court's leave to make a response, to prepare and respond to the prosecution's application. Your Honor, that is what the court done for. And we are ready to proceed.
Yes, Your Worship, for the record, I'm Kakutu Muslim. However, Your Worship, before I proceed to give my response to the constitution application, as an officer of court, it is prudent that we guide court on how we proceed. On the 23rd of January 2026, when I appeared in court, there were always 10 judges people upon which this application was made. A21 who has just been added should not be involved in this application because he was not an accused person. Because I don't know what he feels of. I want court's guidance. Then I can proceed.
This is the reply from, I am just doing.
It's okay, Your Worship. I understand.
He's an accused person and he's here, and I'm saying we're ready to give the charges.
Not surprised, Your Worship. But I wanted him to be.
I cannot exempt him from this file at this point.
I've understood that. I wanted him to know why you are making this reply. Because you are not
And it will affect him either, even if the court gives a ruling, it will affect him. So it is not, I cannot isolate him at this point.
Yeah, I'm also obliged, Your Worship, but I wanted him to understand why you are making this reply. But you can proceed.
Is he represented?
Yes, Your Worship.
Thank you.
Your Worship, the state made an application, and mainly he was concerned with the breach of the subsidy rules, as well as the security of the persons involved in this matter, including the witnesses, which we seek to reply to today. Your Honor, the law of subjudice is clear. And I believe my colleagues and the defense team, as well as the prosecutor also, we understand that matters before court should not be discussed or opinions given on their merits or demerits. Your Honor, from the start of this trial, neither of us, the lawyers and the defense, I'm not sure whether the prosecution has, but neither of us or the defense team discussed the merits or even the demerits of this matter. Anywhere, either in this court because they have not started trial, or even in the public. The prosecution did not even adduce any form of evidence relating to the alleged subjudice. And for us, we can confirm because we know the effect of subjudice in discussing matters. As advocates, we cannot do that, and we are not even about to do it. In his application, Your Worship, the state submitted that the media was doing live coverage in this matter, and he alleges that that was also part of the subjudice, literally subjudice. But I want to clarify this, Your Honor. On several occasions, the prosecutor and this honorable court have been clear that this matter before court, before these accused people, is a matter of the public interest. Your Worship, we also know that it is a matter of public interest. And considering the size of our courtroom and the number of the accused people before you, the courtroom space is small, as you can identify. Most of the people are standing. And also, considering the restrictions from the main road towards accessing this court. At some point, it even affected us, the lawyers, but it was verified. But it still affects the court users, the relatives of the accused people, and the sureties. Your Worship, the media only does coverage on this matter because not every relative of these accused or their sureties can access court. And some of the accused people, including A8, are leaders of the second biggest political party here in Uganda. So they have a lot of following and supporters. Whereas some of his colleagues are also in prison, by covering these proceedings by our media group, it is clearly by the media group here, helps also those leaders that are still incarcerated to follow for proceedings. And many of these details have already been in the public domain since August. So my submission on the subjudice is that the prosecution has not made any evidence or even pointed out any media group or personnel that has commented on this matter in a breach of the subjudice. The second issue, Your Honor, is about the security of persons involved in this matter. Your Honor, the prosecution alleges that the parties involved in this matter, including the witnesses, are facing a security risk because of the media coverage of this proceeding. But I've always appeared in court, and the record can clearly show that the state has always admitted not having concluded investigations in this matter. And therefore, they have not fully disclosed as the defense team. So, neither the court record, nor the defense counsel, nor even the accused people themselves know the witnesses that are intended to be relied on. And you remember, Your Worship, on the 23rd, I even raised an issue about the complainant in this matter. We don't know. So there's no threat on the security where we don't know the people that are threatened. And two, there's no evidence that was adduced by the prosecution regarding any threat. And if there was a threat, a prosecution is in a better position complain and bring the people threatening the death to this honorable court, because I know that is an offense. But in the absence of any of the facts in that regard, I find that the prosecution's allegations are far-fetched and should be ignored by this court. Your Worship, the state is actually in a better position to provide security for its witnesses that are not yet known, and for us as defense counsel. Because Your Worship, we the defense counsel might threaten because we are representing the leadership by the security itself. And Your Worship, for the record, I'm a victim of that threat. Because I was bundled.
Your Honor, I wish to object to this kind of. Your Honor, no. We are here.
I have a police reference to this. I have a police.
And it is because you are suspect in another case. So, Your Honor, let's what business. To object to the way my landed brother is conducting what business. We are here for the response to this application.
Yes, Your Worship, I was giving you a threat that I faced and the condemnation is that because I'm representing these people. I have a police bond to that.
We vehemently object. This application was to regulate the media covering these proceedings, not to ban them. Now, for my learned brother, it is ludicrous that he is going into things that are unrelated.
And that's why I'm going to cancel. Speak to this.
That's most obliged.
Prayers made by state.
Most obliged, Your Worship.
Yes,
because I'm still on the security of the person involved in this matter.
Unless you're saying you enact the state that we are all under pressure.
No. Your Worship, I'm saying that the state has capacity to provide.
Because it seems like you're saying that
No. I'm saying the state has the capacity to provide security to its witnesses. And us, if at all the state. But let me proceed on. As I earlier said, the witnesses are not yet known court, and no witness has ever been presented. So, it is not correct for the state to say that there are no witnesses accredited for us, and that record should be disregarded. Your Honor, I'm going to go to the decision of Justice Lydia Mugambe in Uganda Court Reporters Association Limited versus the Attorney General. Civil Division, miscellaneous cause number 87 of 2014. And it was for judicial review. Please. Your Worship, the brief background is that the Chief Magistrate at Uganda Road had blocked trial in a camera of some accused persons who were allegedly under a high-profile case involving police officers. And upon that decision, the association made a review application for Justice Mugambe. And in Justice Mugambe's ruling, she had this to state while overturning the decision of that magistrate. I've given the court a copy. And Your Honor, in that ruling, the land judge said that the state cannot simply invoke national security to block media. That the state cannot simply invoke national security to block media. It must provide concrete evidence. It must provide concrete evidence about the same with the security. That it is not enough to raise state security without more. Some continuous. It is for the court to determine whether a matter falls. It is for the court to determine whether a matter falls within the exception of Article 41. That is Article 41, access information only. And to do this, the state must produce evidence upon which the court can act. Worship, this was also referred to in the case of Major General David Nyefuza versus the Attorney General, Constitutional Petition number 1 of 1996. This was referred to by my colleague in his application. So, Your Worship, where the state has not provided any factual evidence regarding the security of the persons involved in the matter, the court should just ignore that as a mere allegation. And disregard this application. Worship, in the same decision, Justice Mugambe also emphasized the matter or the importance of an open justice principle. Worship, in that decision, Justice Mugambe emphasized that the open court principle is a fundamental pillar of a fair trial. The open court principle is a fundamental pillar of a fair trial, and that any limitation must be justifiable. That any limitation must be justifiable in a free, fair, and democratic society, as under Article 28, 41, and 43 of the Constitution. Your Worship, court also looked at the comparing rights, and that is page 11 and 12, paragraph 34. In this case, the different judges discussed through the importance of open justice, through hearing in open court, and the role of media, access to legal proceedings, as well as the process to be adopted in such applications, for when it is to be banned. And they referred to Justice Masenke DCJ at page 39 in Major General Bill of the Yakuza versus Yakuza, where the land DCJ by then, as then was explained, that although the right to open justice is not absolute, in each case where derogation is sought, the court will have to weigh the competing rights. The court will have to weigh the competing rights or interests carefully with a view to ensuing that the limitation placed on open justice is properly tailored and proportionate to the end it seeks to attain. Your Worship, the same decision emphasizes that open justice system is an integral part of the constitutional vision of an open and democratic society. Your Worship, as I'm about to conclude on this, on page 12 of the Uganda Journalists, Uganda Court Reporters Association, page 12, and that is specifically paragraph 37. The land judge referred to the case of Bifo, son of Mandile, versus is quoted in the where it was held that justice should be done openly, save in special circumstances for which statutory provision to the contrary is made, and save in certain other very unusual circumstances it is better that a man should not be brought to justice at all than that justice should be done to him without the public being given the opportunity of seeing it done. Worship, it's utmost important that this honorable court be pleased continue allowing the media and journalists to conduct live covering of the proceedings which would leave out any bias of bad reporting or misinformation regarding this matter. Because the media are seen as the eyes and the ears of the general public and any interested party who are unable to attend court. Therefore, Your Worship, the media only acts. The media only acts as a surrogate. Media acts as a surrogate for the public in ensuring accountability within the justice system. Then I would invite my colleague to proceed.
Your Honor, my name is Bobi. Your Honor, in addition to the submissions as led by my colleague, I wish to add on that the prosecution's application to ban the media from live coverage and reporting of the matter before you has been brought with unfairness or in bad faith. Your Honor, I'll refer you to Article 41 of the Constitution. Right of access to information. Your Honor, if court permits, I will reproduce the law. Your Honor, every citizen has a right to access information in the possession of the state or any other organ or agents of the state, except where the release of the information is likely to prejudice the security or sovereignty of the state or interference with the right to the policy or any other person. Your Honor, as my colleague submitted, the accused persons comply with one of the popular political organizations called the NUP. for which they have supporters and followers. When court bars media from covering, having live coverage in this matter, this will be a deliberate denial by the state for the followers of the accused persons to access information related to the matter before you. You know, the law goes ahead and says, except where the release of information is likely to prejudice the security or sovereignty of the state or interference with the right to the privacy of any other person. Your Honor, prosecution has not in any way adduced evidence to justify that media will prejudice the security or that they will interfere in anybody, whether they are witnesses, and that it should be barred from covering this matter. No evidence has been adduced by prosecution. Well, again, Your Honor, I invite court to look at Article 28 of the Constitution. The right to fair hearing. Your Honor, a right to fair hearing is not only on the side of the accused persons, but also on the side of the state. And Your Honor, one of the pillars of right to fair hearing is having the media covering and reporting whatever is happening in court. You know, the covering and reporting by media is not only advantageous on the side of the accused persons, but is also on the side of the prosecution. So that the matter is adjudicated fair on both sides. I submit to Your Honor that prosecution should focus on having this matter heard expeditiously and concluded, other than adjudicating issues that are speculations and conjecture. That the side of prosecution are threatening that the proceedings covered by the media will be prejudiced. Nevertheless, Your Honor, lastly, Article 126, Clause 2, Paragraph E of the Constitution substantive justice shall be administered without undue regard to technicalities. Your Honor, we pray that the matter is administered without issues of technicalities adduced by prosecution, that media will utilize the proceedings. I humbly pray that the application by prosecution be ignored and subsequently dismissed. So,
Your Worship, as brief as I can. One, if I on all of fours, Kuma follow. As I was saying, Your Worship, if I on all of fours had proper my land brother for the prosecution, inform the court that the application is to regulate media. Your Worship, it is on the judicial notice that media in Uganda is already regulated. We have several acts of parliament that regulate media and regulations that do operationalize the said principal acts of parliament. To which among others we have Press and Journalists Act, together with regulations made there under. We have the supreme law of this land, which is the Constitution. Your Worship, also I call upon you not to fall in the trap of the prosecution, since this court does not have the subsidiary law to make laws. The subsidiary law is majorly for local government and ministers. Your Worship, by allowing the application before you, before you go there, Your Worship, I wanted also to bring your attention that actually the government has put up statutory bodies regulating media. The most eminent one being UCC, and I believe it has done a commendable job. I always see a prosecution dragging people, most of TikTokers, whom they feel they have gone against the state standards. UCC, that is Uganda Communication Commission. Your Worship, my land brother for the prosecution should be barred from approbating and reprobating. Why am I saying so, Your Worship? The innocent persons before you, as the Constitution dictates as of now, they have severally applied for bail, and Your Worship, you have denied bail on ground that actually the reasoning them is against public interest. And it is the same state now who is trying to bar the public from accessing information. Yet in all bail application, that was his major ground in objection of that bail application. I pray that the court bars him from approbating and reprobating. You should not eat your cake at the same time you want to remain with your cake. You choose one. Your Worship, the prosecution under Article 120 of the Constitution of this land is mandated and well equipped with security, finance, among other equipments to drag whoever they feel has violated the already set laws regulating the media. And they have been doing so, Your Worship, it's in public domain. Therefore, they should not act on fears and allegations which are presumptuous in nature. By denying the innocent before you and their relatives and the public to access what is actually taking place. Your Worship, having media in a court not only helps people within a court premises, but it sends a message to the intending lawbreakers that so and so has been convicted of ABCD. Much as ignorance of the law is not defense, Your Worship, media does a paramount job in educating the public what is wrong and what is bad. Most of this case before you, which is an awful dream. My grandmother in the village wants to know the Waiswa from your state. But I'm not going to transport her to come to court witness. Your Worship, granting the application before you, it will be a blatant attack on Article 40, Clause 2 of the Constitution, which is every person in Uganda has the right to practice his or her profession. Every person in Uganda has the right to practice his or her profession and to carry on any lawful occupation, trade, or business. Your Worship, these people here are here practicing their profession. Therefore, allowing my land brother application before you shall be an attack to how they earn a living, Your Worship. And they already have an association where they belong, and it also be an attack to Article 29 of the Constitution. Your Worship, Article 29, 1A dictates that every person shall have the right to freedom of speech, expression, which shall include freedom of the press and other media. Your Worship, this will not only curtail them, but even the person who is not here with us, Your Worship, to follow what is taking place in court. Your Worship, Article 120, Clause 5. Allow me to read it verbatim. In exercising his or her powers, that is the prosecutor, under this article, the Director of Public Prosecution shall have regard to the public interest, the interest of the administration of justice, and the need to prevent abuse of legal process. Your Worship, I will let this to us lawyers. The way you prepare when you are going to court, you know you are going to be on media. You try your level best not to be signing up with the court process. Does not only actually help the accused person, ask the lawyers, the media, but even the nature of services, which prevents the prosecution from being cited in abuse of court process, and that's the defense lawyers. That is Article 120, Clause 5, Your Worship. Your Worship, why we are insisting that media actually they have to do live coverage. This will prevent misreporting, and it also will discredit such media house of personality, because the person would have seen or watched the live proceedings. It will be rare and extremely not possible that it will give my brother here more cases. You misreport, you are dragged to court. You have no defamation among others. That is why I'm buttressing the fact that we need media more so in such proceedings. Your Worship, my brothers have all submitted on for great faith. I just want to rubber stamp it and cement it finally that actually it is among the non-derogable articles under Article 44 of the Constitution. I therefore, as I wind up, Your Worship, before I invite my brother. Yes, we are trying all of questions to repeat whatever has been said. I pray that you remain alert, not to be a victim of what my brother wants to throw you in by dismissing his application. I so pray, Your Worship. I will call upon the leader of opposition, George Senyo, Your Worship. Most of that, George Senyo, to stand from there, most of that.
Your Honor, George Senyo, wrapping up the response of the defense team to the application by the state seeking to limit access of the media. The proceedings of court in this matter. Your Worship, there is no urgent reason, none whatsoever, for this matter to be tried in the dark. Because that's what regulating the media, limiting its access to these proceedings will do. Your Worship, someone once said that justice dies in the dark. We should not lend credence to this saying by locking out, by limiting the media from accessing the proceedings of court in this matter. Your Worship, it is public knowledge that the media is always hounded. The media is even assaulted at times by the military, simply because the military does not like the work that is done by the media. It is our considered view, Your Worship, that court should not join those who are hounding the media. Court should not join those who are locking out and persecuting the media, because when you deny them space to do their work, you are persecuting them. Court should instead, in our view, protect the right of the media to execute their noble profession. Your Worship, this is a matter of public interest. And court.
I'm glad we finally agree. I'm glad we finally agree.
And I'm going to expound on my point, Your Worship. This is a matter of public interest, Your Worship. And so the public should not be locked out. Because when we lock out the media, when we limit the media, then we are locking out the public. And yet we are saying this is a matter of public interest. So the media, the public deserves the right to follow the proceedings of this public interest matter. And as we have noted, Your Honor, this courtroom is a very small one.
We tried.
It does not fit even 0.01% of the public out there. The media here represents the public. So when they are here, the public is present and they are following. And now that state keeps saying these people committed a grave offense or something we are opposed to, how will people out there avoid being the dog if they don't follow what's happening here? To know that if I do this, even when it is not disallowable in the law, I'll end up like the accused person. Finally, Your Worship, a sub judice rule that is being reminded of us severally is not necessarily violated here in this courtroom. No. The sub judice rule, which bars all of us here, by the way, on this bar, can be violated tomorrow or even the other day at various media platforms. Not necessarily in this courtroom. So it should not be an excavation, Your Worship. We are alive to this rule, and we don't intend to violate it at all, because we know the implications as officials of court. So the excavation that it gets to be violated when the media is present, that's not true. It can be violated tomorrow on the TV program, on the radio program, and the other day, and so on. So it is our prayer, Your Worship, that the media be permitted and even protected as they do their work in covering the proceedings of court in this matter. We so pray, Your Worship.
I just have something small to add here, to supplement and friends have found it out.
Pastor Joe that says you are coming up.
The owner I'm speaking on behalf of A9 and I have the instructions. I'm not going to take
This
so long.
man so
Kenneth Gideon Lulu. Mine is just to supplement. First and foremost, Your Honor, the main purpose of this evidence rule is to protect the defendant's right to fair hearing. First and foremost, it is not to promote state secrecy as it is in this case. by invoking this rule at this particular time in this proceeding, promotes the right to a fair hearing.
Like mentioned, which part is protected?
Not to protect the not to protect the state, or not to hide the state, not to protect the state from scrutiny. In these proceedings, which are public interest, it's clear that the purpose why this rule is being invoked by the state is to hide public scrutiny. And that is the travesty of justice. This court must be added to. Secondly, Your Honor, the subjudice rule, as it were, has exceptions. One of them, my colleagues have actually expounded on them, that is public interest. Matters relating to public interest cannot be suppressed by invoking this subjudice rule, unless there is a specific intent to interfere with the trial. And that specific intent must be proved. The state has fallen short. Further, Your Honor, fair reporting, accurate and neutral reporting of court proceedings does not breach the subjudice rule. That is right. So again, the state has a duty to go further to show the inaccuracies in the reporting. It has to go further to show, to prove to courts the kind of prejudice that is going to be suffered by the state. None has been shown for. It is clear that the state is going to hide the sluggish manner in which it is handling these proceedings. The trials are not taking off. Bail applications are denied. And the public is interested. And that is the very reason why the state is trying.
The state does not deny bail. The court that denies bail.
Most obliged, Your Honor.
Please correct it.
Most obliged, Your Honor. I'm grateful for the guidance. But what I was trying to say is that the way these proceedings are being handled by the state, no hearings, indefinite incarceration, certainly the state wishes to hide this from happen. And this court should not be put in such a bad one. In summary, Your Honor, just to correct the prayer made by my colleagues, that this application should not see the light of day. It is intended further prejudice these people's these unfortunate people's rights. And we pray you do the right thing.
Yes, Your Honor. We have been joined on the prosecution side by the resident Chief State Attorney, Mr. Hansel Your Honor, back to the application. The prosecution made this application on the 23rd of January 2026. Your Honor, in court that day were all the accused, albeit the three appearing on by video on Zoom. But they were also represented, Your Honor. Your Honor, on the stage date, they were represented by Counsel Kakuru Musini alone. Your Honor, with the greatest of respect, I am constrained to believe that maybe our application was, if not deliberately, misquoted. My learned brother seems to respond to an application that was never made on that day. The application to hold hearings in camera. Your Honor, the authorities that my learned brothers are relying on are in fact distinguishable, not only on the facts, Your Honor. Was it prejudicing? Do we proceed? Most obliged. Your Honor, the response by the defense, I want to believe, Your Honor, that maybe my learned brother respectfully was not attentive that day. The application was not for curtailing the media or locking them out. Your Honor, the application, the record will show. The record will show, Your Honor. Our application was not to hold hearings in Canada. Your Honor, I've taken the trouble to find the Blackstone Dictionary's meaning of hearings in camera. And if you will allow me, Your Honor, the second edition. This is the Law Dictionary.
That's why talking, please.
Dictionary.
You're not here by force, eh? When you want to talk, you step out. No one, I've not forced anyone to be here. So if you feel you're tired or you want to step out and talk, please do.
Your Honor, the Blackstone Dictionary, second edition. I've only been able to find it. Your Honor, the definition of hearings in the camera. It means, Your Honor, in chambers, in private, a cause is said to be heard in camera either when the hearing is heard before the judge in his private room or when all spectators are excluded from the courtroom. Your Honor, the authority that my learned brothers are relying on in response to our application was an application to have hearings in camera. Your Honor, this being an application for judicial review, but a close read of the same makes reference to what actually transpired in the court. Your Honor, at page 1, paragraph 1, it states that prosecution applied orally briefly to have the hearing placed in camera. At page 2, Your Honor, the learned judge, as she then was, quoted the trial magistrate, and this is what she is said to have stated. This is page 2 at paragraph 3, quoting the trial magistrate. The application to share the case in camera is allowed in public interest and the protection of witnesses whose identity once revealed may prejudice the trial process and put their security at risk. Your Honor, why I bring all this out? It is our submission that the facts are distinguishable. The authorities they wish to rely on specific issues.
You want to bring a citation authority. You don't cite submission overall but in that case, we cite for worship, and that is what it is. This is the housekeeping. It's not a time to prevent as a result.
Your Honor, my learned brother is but wasting God's time. Your Honor, at page 3, for clarity, and I'm quoting Your Honor, for clarity, the trial of this case is restricted to court and the court interpreter, the accused person, his defense lawyer, his clerk, and the trial state attorney and court orderly. Your Honor, our application, it is our submission that my learned brothers, the defense, actually submitting or responding to an application that never was. The record will show Your Honor. I will not go back to our application. Your Honor, we are in an open court. The media is in the court. Your Honor, in any case, under section 40, 1 of the Magistrates Court Act, that was cited in that very case. Our application was premised on the law and the court has the discretion, Your Honor. Your Honor, section 40, subsection 1 of the Magistrates Court Act, and if you will allow me, Your Honor.
Your Worship, we have an objection.
It states,
We have an objection. You know, it's a trade law that rejoinder is basically for the lead defense. And my land colleague is alluding to the facts which we not in any way alluding to in our defense. I don't know where my land colleague is getting all this from.
Your Honor, this authority, I believe, my beloved brother.
Even I was present in court that day when the application was made, and I have a record of my own. This letter did not die with any section of them. I'm here.
I don't know why you are doing my job.
And he's trying to maybe.
I don't know why you're doing my job.
But your ship as officers of court don't guide court on
And I will make the guidance.
Your Honor, I'm sorry that I rely
Now,
on
for procedure, I can allow.
Yes.
State, please make a rejoinder in reference to what has been.
Your Honor, I'm referring to the decision they have given in court. It refers to section 40, 1 of the MCA, Your Honor, at page.
Anyone talk about that?
No, when you don't decide what I have to rely on, Your Honor, they don't.
Because I don't think I quoted anyone about the Magistrates Court Act.
Your Honor, they made reference and served the copy to the prosecution.
The reference was highlighted and mentioned.
Most right.
They did not say to retain it. Because they posted the pages and paragraphs.
We are the different pages.
Let us stick to that. Let us not expand this.
But Your Honor, it is really.
Because now you're bringing new facts and new.
Your Honor, they have served the copy. I am at liberty to refer to any
And
part
that's
of
what I'm
this.
saying. They have given us a copy because they wanted us to look at that particular part.
Oh, really? I don't
They wanted us to look at. They would have said look at the whole.
Most obliged. most of that.
But they highlighted and they made sure they tell you the paragraph and page. So refer to that.
Is eating and having the cake at the same time.
No.
Your Honor, my brief. They seem to make submissions that no witnesses have ever been brought to court. Your Honor, witnesses, the record will show witnesses have been in court, and even now, there are witnesses in court. Your Honor, there is an officer. He is in court. If you will allow me, I can introduce him.
No, that is him introducing.
But the record has always shown that we have witnesses in court. And not proceeding does not mean the prosecution has not always been ready to proceed with the hearing. And the case has always been adjourned, Your Honor, for mention, and not hearing.
Are you done with the rejoinder?
Your Honor, we invite the court it is our submission that the facts the authority cited are distinguishable, and in any case, Your Honor, the prosecution's application was not holding these proceedings in camera, but to regulate the conduct, the media. I wish to reiterate that prayer that the basis of that prayer, Your Honor, was to ensure that the witnesses involved, Your Honor, in any case, rights are not absolute, and they are not. They have to be enjoyed, Your Honor, in consideration of the rights of others. The prosecution was not unreasonable in its application. We invite the court to regulate, Your Honor, for the sake of securing these witnesses. The prosecution has in fact disclosed, and so these witnesses are known. For our application, Your Honor, to reiterate and emphasize the application, since my brothers were responding to a different application. We pray that the court will allow our application. Your Honor, we went ahead and cited authorities that are as recent as 2025, except for my learned colleagues who are quoting 2014. Your Honor, we rest our case.
That has been my ability is something on the sides that I can deal with. Later, I will give my ruling. State you're still on the stand.
Your Honor,
What is the business? What is the next business? Because either way that I fall, whether to allow media or not, the case must. So what are we?
Your Honor, we have previously disclosed the evidence we relied upon. Your Honor, we have previously disclosed evidence we wish to rely on. We in fact had a witness in court. Detective AIP Soma, please stand up for recognition. Your Honor, however, we will not proceed. Detective AIP Soma, what's your other name? For the record. Your Honor, he is Inspector of Police Soma Armstrong. Your Honor, he is Inspector of Complainant in this case. Your Honor, we will seek court's leave that we may adjourn so that we will disclose the rest of the evidence. Because, Your Honor, we disclosed up to the 10th witness, rather the 10th accused person. We have since amended and included, or rather added 11 more accused persons. In the interest of justice and the fair hearing, Your Honor, we are happy to disclose the rest of the statements of the accused persons and the rest of the documents and bits of evidence that we wish to rely on, Your Honor. The court has guided the way that we should stop at accused number 21. Your Honor, as the prosecution, we will if need be, Your Honor, address the court on the same at a later date. But for now, Your Honor, we wish to disclose the statements of the 10 accused persons. Your Honor, we don't intend to ambush the defense. We will disclose as soon as possible so that this court, Your Honor, so that the hearing of this case may be fixed. Your Honor, this is also, as I say, in the interest of justice, in the interest of, we don't want to appear to ambush, Your Honor, again, I will state. We will disclose and then thereafter we will seek court's leave, fix the case of hearing. We pray that there be no Your Honor, we will pray that the court will release our justice.
This case was came before this one August. Partial disclosure was made. The defense still. The Washington State talks about that they intend to further disclose any other evidence without certainty. It's against.
I think clear. You're referring to the from it says latent.
Yes, there is no certainty. It says at any time earliest possible. We need a certainty so that we can guarantee and safeguard the rights of this trial.
So you're asking when?
Certainty, yes. That's
Your Honor, I have the police file here with me. And of course, it is at their cost. Yes, Your Honor, we will have it disclosed.
Your Honor, my name is Bobi Wine. In addition to my colleague,
The court order is is now coming to monitor that on their own cost.
Your Honor, on addition to my land colleague,
Yes, Councillor.
it is true that prosecution disclosed and that prosecution has a witness in the court. Detective Armstrong, Inspector of Police. Your Honor, we have a witness statement for that witness. And we are ready to proceed with him as well. Your Honor, this blatant talk by the state that he needs time to have the matter alleged is categorically a ploy to delay this case. The first accused person in this court took plea on the 14th day of August 2025. A1 and A2. It's now close to over 6 months. 7 months. The case has never kicked on. We are playing semantics with the prosecution, having applications and applications at the detriment of the accused person. We strongly object to the adjournment. The witness is in the court. We are ready to proceed. In the alternative, Your Honor, without prejudice, court evokes the provisions of section 119 of the MCA. Of the MCA. 119 of the MCA. And dismisses the same for want of prosecution. When the prosecution is ready to take on this matter, Your Honor, they have a right to reinstate. They reinstate at any time, the next century, if they so wish. But again, Your Honor, if court also inclines to this as counsel has earlier stated, we should know when have the full disclosure in this matter done and have a quick trial as early as next week, Your Honor. We so pray.
Just to supplement what you said, we also object to the endless penalty. We object to the endless adjournments. We point to the deliberate delay of this matter. To have this matter dragged, there's no other way to put it. For the 9th accused, rather for accused number 9, we don't need to this is in court. Where that since the witness is in court, we already started with the witness. It's not just five rules going unless it's just unless the match which we hope court. First of all, I concur with my colleague, my friend, that dismiss this matter for lack of prosecution. under section 119 of the MCA. Because justice should not only be done, but it should be seen to be done. And this honorable court has no other way than to stress that this case has been in court for a very long time.
Your Honor, with a lot of respect to my colleagues, counsel, section 119. If you allow me, quote verbatim. Section 119, subsection 1. If in any case which a magistrate court has jurisdiction to hear and determine, the accused person appears in obedience to summons, serves appoint him or her the time and place appointed in the summons hearing case, or is brought before the court under arrest, then if the prosecutor, having had notice of the time and place appointed for the hearing, the charge does not appear, the court shall dismiss the charge unless for some reason it shall think it proper to attend the hearing of the case. Your Honor, we have just informed the court that we have the witness report. Appearance and proceeding are two different things. Your Honor, but if my learned brothers wish.
I want you to first deal with the first issue. Can you proceed?
Your Honor, this honorable court, unless the court will go back on its earlier directed the prosecution to disclose fully. We have indicated, we partially disclosed. We are ready to disclose today. And once we have disclosed fully, because we believe, and as officers of the court, it will certainly prejudice another, if we have to keep calling witnesses probably that have already been heard, in the interest of justice and to save court's time, Your Honor.
So let me clarify this. You are the main parties in this case. The state and the defense. You presented a witness. The defense is saying they are ready to proceed. I don't see how I come into with a direct.
What's your plan, Your Honor?
If I may,
Directive, what do you mean? That you don't proceed? Yes.
if I may, Your Worship,
Senior state.
this matter was not fixed for hearing. It was fixed for response of the defense to the application that was made by the prosecution. Counsel has clearly stated that they received partial disclosure. Your Worship, it's in the best interest of everyone that we disclose everything that we have to the defense so that we have a speedy trial. We won't have issues to do with you did not disclose this to me. All those arguments should be dealt with. We pray that court gives us another date. We meet with the defense counsel, we disclose fully whatever we have.
Disclosure.
Yes, Your Worship, no problem. We have no objection to that. The witnesses in the court, that's true. But the case had not been fixed for hearing today. Your Honor, it's on court record that the case had been fixed for response to an application by the prosecution, not for hearing. We therefore pray that the court answers the judgment to enable us to fully disclose to the prosecution and prepare our case for trial.
Your Honor, to supplement what my learned brother has, the court will in fact have conference with either side and fix a date for hearing. And today was not for hearing. Your Honor, we did not fix it for hearing. That is what my learned brother has just told the court.
that one was hard, perfectly and good. I thought you were bringing up another fact. I want us to appreciate the dynamics of this case. Both sides, state and the defense team. I think I have not appeared in this case only when I took leave. That was in October. You have to look at the dynamics that I opened this, I started this case on the 14th day of August. And today, the 27th day of February, I have not had one which I would consider absurd. They applied for bail, some have not. I don't know if any intended to apply for the same today.
Yes.
We have intention that we can get through our pretrial remedies. At the point I stand, I am between two sides, which I must balance. These persons are here, ready to hear why they are here. State, I accept that today was not a day for hearing. There was an application in the reply is only took most of the time there. And my time is actually fast spent as well, because I have other matters to attend to. From, I think, 11 something, I'm here, and it's coming to 2. I'm going to allow, because I must also reply to this, I need to make a ruling on the same, but I want us to look at the dynamics of this case. These people need to hear what the state has against them. They should know why they are here. And if they are not, then we invoke 119 next year. Yes, because we cannot hold them at ransom and we don't know what we are saying. So get ready. Now I'm going to give a date for hearing. And I want us to be clear, there is no other big pong. Let us have a date for hearing. And we hear what the state has to say. Is there anything that is going to bar us from hearing on the next hearing date? Is there something that is going to bar that I need to address today? Tell me so that we do not have again another forth and back. Is there anything that I need to address from the state that will bar us from a hearing in the next day? Is it there, the state?
Your Honor, I have just one thing. I have only one humble request, Your Honor. In the event that court gives us that fateful day for the adjourned for hearing.
The choice of words, The choice of words. Okay.
Your Honor, the court adjourns this matter. Your Honor, we pray that on that day, if prosecution is not ready to proceed, court either invokes the provision of section 119 of the MCA or grants bail, actually grants a court bond to the accused person. It's my humble prayer.
The two persons are actually represented, right? Let me get my admin. The assistant. The assistant staff.
Your Honor, the prayer by my learned brother, Counsel Sebutu, is really untenable. Not enough.
Give us the reason why.
I don't know how counsel can, it is not that either you give this or that. He's putting the court at ransom.
It's a prayer.
Most of
It's a prayer.
He's a good
I am not adjusting. It's a prayer. And I can decide to be peaceful like a prayer.
No, he seems to suggest that it's either this or that.
He has given his suggestion. He has given his suggestion. So I cannot, he's giving his prayer. He has not said go and do that. It's a prayer. So I want us to agree. Is there anything that is going to bar us from here? If possible, can the state come with 2 witnesses?
or more.
Or more? Can the state get for us at least 2 witnesses and we start? We already have witness number 1, who is the complainant, present in court. So the other side. The other side, the Hi, Doreen. I cannot hear you properly. You can repeat what you were saying. I could not hear that. I could not hear that kind. Yes, yes. A simple reply to that A8, that is heightened. Please address the head of this court, who is not me. And I was not privy to that communication, but the head authorized it. Maybe in the next hearing, I can address that properly, because I was never addressed. It was to the head of this court. So I will also make some inquiries of the same, and I find out the proper answer to that. Thank you. I hope you had this. Her concern?
No, we didn't.
Okay. Her concern was to, she wanted to know why they have failed to present them physically in court on several occasions. Yes, that's what that was her main concern. So she wanted to attend the court physically as the rest are.
Your Honor, it's actually a prayer I want to make. That at the next appearance, trial starts, the 3 accused persons get to be present physically, because it's important that as their lawyer to get to confirm with them, share, sometimes in private and all of that, so that they can engage with us. And now we are not able to. Technology is failing us and has done so digitally. So we pray that they get them here. It's important because part of fair hearing is that they get to know what's happening, how with their lawyers and all of that. It's our prayer.
Yes, I want us also to look that we are trying as judiciary to make things easy for those who cannot attend court physically. For now, it may look like it's a detriment, but in another case, it may look like it is to your own benefit because we are able to attend court wherever you are. We have handled hearings even when people are out of the country and they attend court, so it also can be to your advantage. Maybe now it may be to your detriment, but it's one way of access to justice. That judiciary is also making things a little more flexible. And that's why we have the ITMIS, so that you can know how the case is running, even when you sit at your comfort of wherever you are. No, everything with a start, even life alone is problematic, but we are still living. So we try. Yeah, so it's also another innovation that we are trying to look at for each of us to actually benefit with the changes. The world is coming to a change, and we're embracing the e-system. Yes, so it's also one way that we can attend to wherever you are. So, but now this is a prayer from you that you really need these people to attend. I will share convert the same message to the head of this court because I don't have the powers to. Because I've never even addressed to that. When prison is writing, I'm not in copy. Yes. Because I'm not the head of this place. So, but I'll address it to her and she'll give me the right information to convey back to you. Yes.
Maybe you have an exchange with
True. Yes. That's the approach. The person in charge is here. She's on my side here. She's our systems administrator.
I have another one more humble prayer. The next hearing date, I pray that since the defense has a number of lawyers and some are not even coming, and we wish to have this matter heard expeditiously. We pray the side of prosecution that they bring us many witnesses as they come, because we are well equipped as a team to handle.
So your prayer is that prosecution?
Yes, Lord.
I'm glad that the arrested state actually managed to appear.
Yes.
Is there a reply for Council Semuju regarding that prayer? Because I don't think I have so much power over that.
Worship, we shall bring as many witnesses as we can, considering the circumstances.
Considering the circumstances.
Secondly, time also matters. God normally gives us 9 or 10, but you realize that prosecution comes here.
Your Honor, we object to that. We are offended. My learned brother, no wonder he's looking away from the cameras.
No, I'm not.
Okay, now what is going to stay?
Your Honor, we have always been here at 9. We have started later than 9 simply because either some prisons have not reached here. We get prisons we have inmates that come from Kasanga, and sometimes, Your Honor, you will not, maybe traffic, but it is not the prosecution.
Your Honor,
So my learned brother, that is below the belt, and please, you should
My name
know
is
that.
Patrick. I want to attend to other litigants. So now what is going to happen? The good thing, we work as a team. Even when I'm present at 9, I cannot start without you. Even if you are present, if President is not here, we shall not. So I cannot put the blame to one particular stakeholder. But at least we are here, so we can address that all of us at home.
Most of them.
So I don't want to put blame to one
It's my humble prayer that you give it as a directive vision and house the accused persons in court on time.
The next hearing that I'm giving, we shall start court at 10 immediately. So I'm glad that we are all here in attendance. The prison is here, the accused persons and their lawyers and the state, including myself, I'm also party to the same.
I want to make an application today on behalf of K9. Yes, Your Worship. I have an application and I'm going to be very quick.
Your Honor, for experience, maybe. And unless my learned brother has uploaded the things, we will probably. When did you upload?
He uploaded.
When? Because we want to be able to respond. If it's about saving time, so that we can respond. When did you upload?
He uploaded, I think.
This morning.
But it's not there.
So, Your Honor will not be able to respond, and that will not save court time. If it will please Your Honor, if the court adjourns, we can we pray. It is our prayer, that when they apply, we are able to respond, because by then we shall probably have that.
Can you allow me to be a counsel?
Most obliged.
Allow me to be a counsel. I have not even had.
You all are most obliged, and I think a prosecution should overzealous, not to recover. Your Honor, I just have instructions to apply for bail on behalf of N9.
This is a rig, because N9 is captured in the first application and also the application for mandatory bail.
Yes.
N9,
Yes.
that is Saudi Madad.
Yes, Your Honor.
It's captured in the first application
Yes.
and the one on mandatory bail.
Yes. The circumstances have changed, Your Honor. Your Honor, Kenneth William Munutu. The instructions that apply for bail on behalf of A9 on grounds that A9, Your Honor, has been put in poor health. This honorable court has witnessed those scenarios in respect to A9. You can remember, Your Honor, the previous time when you were applying for bail, she had a very serious health challenge. Secondly, Your Honor, A9 qualifies for bail on the ground that she has been on remand for now 7 months. Yet, no trial is underway. Your Honor, bail is a constitutional right, and it is not an acquittal. Don't want prosecution to treat it as if it is an acquittal. It is just to give an opportunity for the accused to defend herself while coming from home. That is not prejudicial to the prosecution at all. This case is bailable. This honorable court. The accused person, Your Honor, has first of all been the principles or within the jurisdiction of this court. She has, Your Honor, furnished letters of confirmation of residence, which are, that's Your Honor, and we have uploaded those to the system. She has, Your Honor, substantial sureties who have well been.
There was another matter before the chief magistrate. Why people who are here that was supposed to be before the chief magistrate?
Abantu abaliwo nabo nga tebalina okwatiranga amaaso ga chief magistrate.
Your Honor, we handled most of the reports. We only have one for her, for one of the.
Yes, Your Honor, and where this accused person has substantial sureties who have been briefed on their responsibilities and which, Your Honor, they have fully understood. And their primary responsibility is to produce the accused in court whenever needed. They are substantial because one is the mother by the name of Deborah Namiro. Deborah Namiro, Your Honor, has produced a letter of residence before this court. She also has a valid national identity card. National ID card. Copies of the system. She has furnished another witness, her father, by the name Balaga de Simpo. Balaga de Simpo, Your Worship, has produced a letter confirming residence and the national ID. They are on the system as well. We also have copies we are glad to share. For the avoidance of doubt, she has even furnished a third surety by the name Nasuga Damari. This is an auntie who has also furnished a letter confirming residence and a valid national identity card. Well, I will probably find those substantial. You know that this person has a family. He has a family, the breadwinner of our family. And even the presumption of innocence, this court is mandated to exam. There does not seem to be any compelling reason why we should not exercise the discretion and grant bail. Like I just stated, Your Honor, we will not take this as an acquittal, but just as an opportunity to attend court when they're coming from home. It is not prejudicial to the prosecution. And it has its tenets. The right of bail has its tenets. in the principle of a right to fair trial. Because denying bail is as if to say that these people are convicted. They are not. So, in a nutshell, Your Honor, without wasting too much of your time, the precious time, for you to exercise your discretion and release A1 A9. Even A1.
So I just want to jumble up. Yes, I wanted I interjected me, so I wanted to wait for you to see it. I'm seeing a reapplication. This is by A9.
We have
And I've not had the opportunity of hearing A21, the first application. So I want us to have an orderly manner if they intend to. And if they don't intend to, and we just start the hearing, then we can go for that. So I want us to have some orderliness. So I'm asking the defense team. Is this it?
We have instructions and
For the first timers or
first timers.
the others?
Even the other first timers as of the right to make an application and then they apply.
Because from there, I think Lutaya did not make an application. From A11, there was no application made. I think intended actually. I'm seeing a hand up. So, are we dealing with that?
Yes.
That is from A11.
Yes, Your Honor, my colleague is going to.
Because I don't want a scenario where one person then we reply, then another one person.
No, Your Honor, from A11, we have never made a paid application.
Yes.
And we are ready to proceed with the paid application. Two, we are also having instructions from A1 to A10 to also do a fresh paid application. So with your guidance, you can pay the outcomes for the entire paid application, focusing on the ones who have not applied for and the ones that want to do
I want the from A11.
Yes, Your Worship, we associate ourselves with the terms of the application made by council for A9.
I think I just need to see that
We have to do the
then I also want to put review statements, upload this document for those ones. Yes. Let us present the physical. Let us see the surety.
It is for A12. We have Riga Samson. Naso Gaiva Janet. Riga Samson is a resident of
Where is it?
Your worship, for the record, we made an application for A11, which has never been for Libya. The day we made the mandatory made application.
Who are the authorities? Just remind me of the day and tell me something. Before the day? I think I'm seeing this. Pastor Samuel, was it Nami Sarah and Kwesi Robert? Okay, I see that. That's where it is.
We still consider the same thing.
That was on the 18th of November.
Yes, no. So the first surety is Riga Samson for 8 years. 36 years old. Is a resident of Lugara zone in Rubia Parish, Rubaga, Kampala.
Let's have some quietness.
Is a technician. And he's a workmate with the applicant. His mother is on telephone number 0772 87 92 62. 0772 87 92 62. The second surety is Nansuga Everett Janet. I beg your pardon. We have Narukuma Diana. Narukuma Diana. The resident of Lugara zone, Rubia Parish, Waga division in Kampala. Age 27, is a shopkeeper.
Take charge. Those who are making noises, you send them out.
Yeah, in Kampala, he's a shopkeeper. He's a sister to the applicant. And the telephone number 0751 40 99 95.
We proceed to A13. We have Mgerwa Yusuf and Mrs. Edward. Mgerwa Yusuf and Mrs. Edward. Edward is the first chief in worship. He's 34 years old. He's 34 years old. He's a resident of Mutajaz A zone. That is in supervised in matching division in Kampala. He's a mechanic. And the brothers, the applicants, on telephone number 0706 92 63 52. Muwonge Richard. Where is Muwonge Richard? Muwonge Richard. Muwonge, where is the student? Your Worship, we have an introductory letter of Muwonge Richard 13. As a resident of Amazon Village, A13. As a resident of Amazon Village in Ruwafu Parish, matching the division of Kampala. Proceed to A14. We have Nampi Jamaki and Nancy Olivia.
We have them in court.
Now we start with Nampi Jamaki. He's 43 years old, a resident of Agati zone. In Zira Parish, Nakawa Urban Council and Kampala. She's a business woman and operates a retail shop. She's a sister, the applicant, the elder sister of the applicant. She's on telephone number 0700 94 77 26.
Court ordering.
Second sheet. Relationship informs that the two solutions for one for A13 and A14 have been denied access.
It's a gate. They have straight. They have what one. Whoever it is, that entry.
Worship maybe with the red is the F15. Until then, is F. We have Namte Sara and Kavega Majid. Kaiba Abubakar. They are for F15 TV. So we start with Kaiba Abubakar, 37 years old. He is a butcher man and works at Kariro Market. It is the uncle of the African. The uncle of the African and on telephone number 0705 17 68 94. The second city is Namde Sara. Namde Sara is 40 years old. She's a businesswoman. Operates retail shop in Nadete. She is a resident of Busega Central C zone in Rwanda Division, Kampala district. She is a friend to the African. And the telephone number 0700 96 27 33. We also have an introductory letter of the African itself as a resident of Waiswa, Kazo, counted freelance. We proceed to A16. A16, we have Uganda Price and Kaseke Letoni. Start with the Uganda Price. 45 years old. A resident of Zangu Central Cell, Ajas Town Council in Waiswa District. He's a mechanic and works in Mengo at Kupa House. He is the elder brother of the African. And on telephone number 0703 82 23 68. second one is Kaseke Tony. Tony is 42 years old. A resident of Nakuwade. In Musare A, Wakiso, that is in Wakiso district. He's a mechanic and works in Endeavour. He's the brother to the applicant. His on telephone number 0755 35 35 35. We have an introductory letter of A16, Your Worship, as well as the top Nakwate. Saturday, that is what so. For A17, we have Sempungu Ali and Seba Shafaru. Start with Sempungu Ali. He's 55 years old, a resident of Wangu village in Kawoa Parish, Rwanda division in Kampala. He is a mechanic. He works in Wangu. He is a brother to the applicant, Your Worship. And on telephone number 075. Telephone number 0754 27 18 23. Second shoot the Sebaton Farouk. He's 33 years old, a resident of Wangu village in Kawoa Parish, Rwanda in Kampala. He is a border rider. Brother to the applicant. The telephone number 0700 160 292. We have an introductory letter of the applicant as a resident of Wangu village in Kawoa Parish, Rwanda division in Kampala. We proceed to A18. We have Bade Nicholas and Nassos Process. Start with Bade Nicholas. He's 33 years old. Resident of Musanji Central in Tengera Town Council, Wakiso District. He is a businessman and owns a shop. He is electronics in Musanji. Is a friend to Africa. And on telephone number, the friend to the African, and telephone number 080 0701 19 35 0701 19 35 85 85.
That's why the matter before me? What time? Sorry. Which day? Get for me now. I didn't Simple, right? Yes. Looking to the diaries for Wednesday and Thursday. Let me make a note. I'm sorry for the inconvenience.
Yeah, we proceed to the second Tuesday, Your Worship. Naso's process, 32 years old, is a resident of Manja in Sanji. That is in Chegera and Waiswa district. She is a hairdresser in Sanji. And the telephone number 0701 72 84 98. We have an introductory letter and the national ID of the applicant as a resident of Sembe, in Mayawad, Shengera Town Council, and Waiswa District. Proceed to A19. We have Karanzi Andrew and Nabudu Rita. Karanzi Andrew and Rita. We start with Karanzi Andrew, who is 59 years old. The resident of Kasubi Zone in the Rubaka Division, Kampala District. He is a farmer and a businessman. He is the father-in-law of the applicant. And the telephone number 0757 92 0910. Second street is Nabudu Rita. Nabufu Rita is 48 years old. A resident of Kasubi, Zone 1, Kasubi Parish, Rubaga Division, Kampala.
People are still murmuring. I don't know over what. Someone is really having a conversation. What order? They identify those funds. Let them get out.
She's a businesswoman, Your Worship. And owns a retail shop in Kasubi. She is the grandmother of that. And the telephone number 0755 513352. We have an introductory letter of the applicant and a copy of the national ID card. The resident of Kasubi, Zone 1, in Kasubi Parish, Uganda Division, and Kampala. Proceed to the ones for 820. We have Napu Devi, Ndeme, and Narunkuma Diane.
These people in court, and
Namu Devi.
I'll partially handle the bail application for 8 months. Your Honor, we have two sureties for 821. And the first surety is Nagawa Sara. Where's Nagawa Sara? Zahara, yes. And Naka Kembo Josephine. Where's Naka Kembo Josephine? Your Honor, Nagawa Zahara is a resident of Kawemi of Wandege ya Soweto village. Wandege ya Soweto village, Urban Division, Kampala. Tell court your age.
22.
How old are you?
26. Sorry, 33.
Repeat again your age.
1990.
34. Tell court, what do you do for a living? Where?
One day.
And how do you call the accused person? Is the accused person your biological brother?
Mama ni daughter yangu.
Tell court your telephone number.
0704 34 94 36.
Your Honor, we have a second surety, Naka Kembo Josephine. Naka Kembo Josephine is a resident of Kasubi. Kawala Mugema Zone LC1. Kawala Mugema Zone LC1 Kasubi Parish. Kubaga Division. Kampala. Naka Kembo, tell court your age. How old are you? And what do you do for a living? You say what? So where do you sell your shoes? What is your relationship with that person?
My husband.
What's your telephone number?
Your number is 0756 300 56 300 681.
Your Honor, on addition to the duties, accused has also presented to court an introductory letter reading Segawa Shafiq, resident of Kawala, Ugema Zone, and he is also national ID. Nini number 96024-104 PWP. Your Honor, Your Honor, F13, F14 sureties were blocked outside.
By the name of
If you're going to continue submitting, let my colleague. You know, on addition to the bail application already submitted, you know, A1 to A11, A1 to A11 had earlier applied for bail. And their sureties were found substantial. But the only issue was that there was an public interest as a reason for their denial of bail. You know, we pray that all applications for A1, A11 No, I beg your pardon. A1 to A10. Their switches were found substantial. We are humbly pray that court adopts the same sureties for their application. Save for A11's bail application, Your Honor, the ruling was never delivered. In the circumstances of Your Honor, I pray that all sureties presented for A12 to A21 be found substantial and court grants accused persons bail on such lenient terms and conditions as this honorable court deems fit. We humbly pray.
Your Worship, we are unable to respond at this moment. We have received 10 applications to date. We have just been served with the petitions. I believe some of them have not been uploaded. Your Honor, we pray for shorter damage to respond to the application. And also to verify the documents that have been used to submit from software.
Your Honor, I have no objection to that, except that we want to pray for shorter adjournment if it can mean next week. We have no
Also
problem.
looking for that short adjournment.
Yes, Your Honor.
Then your people some matters performing.
Your Worship, in addition to submission, my concern is that now we have these bail applications, we also have a ruling to make. And I don't know whether we shall proceed on that. In my opinion, would be to give a shorter adjournment, do away with all these rulings and applications, then fix it. That would be my opinion. Ruling on
Because you need to have a plan then like this.
No.
It doesn't, but in my opinion, the court is going to be provided. So things are the same.
Most of that, Your Honor.
They're outside for how long so far? So I want to see that we can move this by when.
Your Honor.
So let us make a plan for the next, that is what state is, senior state is trying to bring across.
Your Honor, before court takes leave, Your Honor, the sureties for A20 via Mire Baruku Faru. Your Honor, these sureties, Your Honor, once we are denied access to it is my humble prayer, Your Honor. Your Honor, I am afraid that for the next hearing, we shall produce them, Your Honor, in court for purposes of court verifying and identifying them.
After time on it, that if one state can have a look at them as well, that we consider
Most of that.
That's and we apologize. What are we doing in the next stage?
That's what I was trying to do.
I really the small one for the other one, so you have shouldn't be a big. That's a small ruling that can come in any court sitting. It doesn't buy anything from happening. Yeah? Because whether with or without, I will still proceed with the case.
We have also the response from the state, and everything there under. Not a rejoinder, if any, from the defense team. So that I can have oh, there is no objection. Okay, I'm looking for near.
Your Honor, that immediately we can proceed with the hearing. That cannot pass for
Because we can talk and rejoin until the next morning.
No.
That's my concern.
So let us put to the 13th of March.
Your Honor, 6 is available. We shall be in this court. Of March. I'm surprised.
You'll be in this court?
Yes, Your Honor. Before Chief.
And actually, we share the same courtroom with Chief. That's why I was asking earlier on if there are people inside here. So I don't want to inconvenience, but I also still have it covered here. So you see my mother and this is 9, this is 10. So I'm trying now, I'm pushing it to 13 because I'm going to not, I have 2 other matters, but I can fix you here. So I'm trying to fix because then they are. I like it big in the open because you may think I'm maybe in one word against you, but that's how I'm standing now. Now that is the issue because it seems that I have a bunch of let us do 10:30. Let us do 10:30. So we shall be hearing from the state and rejoinder.
Subsequent here.
Bring for us just 1 minute. What does feel for the last 6 months? Okay, let us do that for that day. Okay. Thank you for attending my course. See you on the 13th day of March at 10:30.
Thank you.
You feel Waiswa. Siwono mulangizi bagenda musozaka
Who is the accused? That's the question.
Susi.
Uganda versus Waiswa Alex Mufumbiro.
Johanna Semuju from, together with Selum Kumar Farouk, Kakut Musime, Kato Musime, Senyoni Joel, and Nantes Juliet Yona for the accused person.
Your Worship, the case is carried out to be
contrary to section 21, subsection 1 of the Penal Act of 1998. The particulars of the offense are that on the 4th day of September 2025, or thereabouts, at the National Unity Platform offices in Makerere Kapule, Wandegea, County Division, in Kampala District, infected persons committing an offense against Ugandan security personnel to wit, you understood the charge?
I have understood that.
Yes, your worship, I have a prayer to make. Hello, Mafaro. Your worship, my prayer is to have the same charge which has just been read. The charge should be expanded from court records. And the accused person before you be set free as far as that charge is concerned. For the following reasons. One, which is the disguised transfer over charge. Over charge. It is a disguised transfer over charge. Two, I'm going to expound that, Your Worship. Two, the prosecution is in abuse. It is in abuse of legal process. I'll start by expounding on round one, which is the disguised transfer, which disguised transfer is legal law. You know what the accused before you was charged with the same offense in the Chief Magistrate Court of Nakawa, at Nakawa, in the month of August 2025. And I was among his lawyers. Your Worship, I beg your pardon, the month was September 2025. Your Worship, the accused applied for bail, which were over 3 attempts, including mandatory bail, which were all denied, notwithstanding that the trial magistrate, Manya Frank, was arguing with us in as far as the sureties are concerned. Your Worship, the charge sheet underwent 2 amendments. And the recent one was on 21st October 2025. A copy of the charge sheet is there, Your Worship. Most of right. But I also call court to take judicial notes that there was a case against him, but I will upload on it. Most of right. Yes, Your Worship, we appeared in that court more than 12 times. Not until raising several points of law, not until on the 12th day of February this very month, 2026, that I personally raised a penal point of law in as far as jurisdiction of that court and how it's concerned. That's geographical. By inviting that court to look at section 35 of the Magistrates Courts Act, and also by emphasizing that jurisdiction is not an act. And no court can transfer or assign jurisdiction. It is a creature of statutes. Not until Yolan brother reached the point where his hands were tied by tribalism, mayorship, and he dismissed. Because he had wanted to transfer the file, and I told him you cannot transfer because you have no jurisdiction. So his only leeway he had was to dismiss the charge. It is the same charge as you read. Your Worship, if you allow me, I will upload the hard copy of the ruling, and the proceedings for that day is there. Your Worship, the point here, what I'm saying is a disguised transfer or assignment of this charge sheet from Nakawa to this court. Disguised transfer, stroke assignment of the charge sheet from Nakawa to this court. Which I informed me and it is illegal. Your Worship, in the case of Musoke Chibuka, Justice Musoke Chibuka, in the case of Kasivante Moses versus Kakongore Singh, Malwaka and another, it was Kampala Electoral Petition number 23 of 2011. What did this say? The term of distribution is not a term of act. It is a term of law. It is a term of very expensive legal import. It embraces every kind of judicial action. It confers upon the court the power to decide any matter in controversy. It presupposes the existence of a duty and it constitutes court with full control over the subject matter under adjudication. It also presupposes full control by court of the party to the subject matter under investigation by it. Jurisdiction defines the power of a court to inquire into facts. To inquire into facts, to apply the relevant law, to make decisions, and to declare the final outcome of the subject matter under its inquiry. Most of that, Your Worship. You can tell me when I stop, Your Worship. Most of that. I will share. Yes. Your Worship, he went further and said that it is straight law. That no court can confer jurisdiction upon itself. It is equally true that no court can assign or delegate jurisdiction. Your Worship, that makes the basis of my point here. That for the past 7 months, he appeared in Chief Magistrate of Nakawa. No witness was brought. All his bail applications, including the mandatory one, were denied. And it took us, the defense lawyers, to raise that point of law, to dismiss the matter. Immediately after dismissing it, they have come up with the same charge sheet. Your Worship, this exhibits and rubber stamps that the prosecution has failed on its mandate envisaged under Article 120, Clause 3B. You permit me to read it. The functions of the Director of the Prosecution are the following. B. To institute criminal proceedings against any person or authority in any court with competent jurisdiction. That is the catchword. With competent jurisdiction other than a court martial. You want for the prosecution to take it as a punishment tool against the innocent, right from to drag him to court, well known that court never had competent jurisdiction. Well known that he had stood for emptyship. Nakawa East. Well known that he had to campaign or to solicit for votes. All these were brought attention of the trial magistrate and even the prosecution. in our bail application. They kept him under custody for 7 months, well known after his keeping in him being in custody is illegal because the court had no competent jurisdiction. And now coming to this very court, Your Worship, with the same charge sheet, this grossly exhibits and cements that the prosecution has on all fours without any fact failed on its duty, which is enshrined under Article 123A. As much as the prosecution has the legal mandate to institute criminal proceedings and discontinue, they should not be doing it as a punishment and in a prejudice to the accused persons. Your Worship, the same Article 120 makes it mandatory for the prosecution to ensure that their mandate is not abused. And it dictates that people must act with accountability, independence, and in the public interest to avoid abuse of legal process. You watch just imagine. He was in custody for 7 months on illegal charge sheet. Most of that. Yes. Your Worship, I know and I call upon you. You apply and you widely put on your judicial assurances as you have always done. I'm confident you agree with me entirely and totally that the charge sheet before you, it is a disguised assignment from our court to this court, whereby the law makes it legal, since it is a free, his jurisdiction cannot be sustained. If it had any other offense in it, but it is the same accused person, the same offense, the same provisions of the law, they just changing the case number. Your Worship, I call upon my brother to cement the submission.
Your Honor, I send you from. Your Honor, in addition to my land colleague, my humble submission, Your Honor, is on the effect that the charge sheet and the charges are incredibly effective. The charge and the charge sheet are incredibly effective in as far as it affects the accused person retrospectively. Affects the accused persons retrospectively. Your Honor, Article 28, Clause 7 of the Constitution is to the effect that no person shall be charged with or convicted of a criminal offense which is founded on an act or omission that he did not, at the time it took, let's constitute a criminal offense. Your Honor, the charge and the charge before you and the accused person was at one time appeared before a judicial officer. Was at one time reigned before a judicial officer in Akawa. In criminal case number 5. Your Honor, emphasizing the issue of retrospective. Yes, it is on the same ruling. If I may beg to look at the ruling, counsel as necessary. It is criminal case number 572 of 2025, Nakawa Chief Magistrate's Court. Where court discontinued the charge and set free the accused person. It is now quite absurd to have the same charge and the same person appearing on the same before another judicial official in another court. That enough affects the accused person retrospectively. Your Honor, I invite you to look at the case of my next prison is a Twitter. No. I can even abandon it. No, I abandon the authority. But my emphasis here is that I'm not emphasizing on the authority, I'm emphasizing on the point that the person that accused cannot be charged retrospectively. In the same scripture, I humbly gave the same bit, struck off the charge and the charge sheet, be struck off the court record, and the immediate accused being acquitted.
Do you want to present what you do as a state?
Your Worship, actually, I'm just going to speak as a suspect who is in this law.
You know as I'm representing you.
They have legally. They want to speak to your human power.
Human power.
Yeah, it keeps the humanity in every individual. Your Worship, on the 6th of September, I was abducted from this court. Yes, 2025. I was abducted from this court. I was attending court stand surety of colleagues and subordinates who are being charged. And as a senior citizen, it was incumbent of me not to abdicate duty, but to come and stand surety for my colleagues. When court stood over, I was abducted by armed military men, driven in an unlicensed vehicle to whereabouts until I was dropped in one place. As a law-abiding citizen, I waited for the next stage, and Your Honor, I was charged in this honorable court on the 8th. Later on, so from the 8th, I want court just to take a pattern of what is happening, whether it amounts to a persecution or not. From the 8th to today, this afternoon, I have been attendant to this court on, of course, a different charge. But at the same time, a few days later, first of all, they wanted to take me to court at 7 p.m. from Luzira prison. And on my character and insistence, I refused. And the following day, on the 22nd, still without my knowledge, I was driven to Nakawa Court, charged of the same account, like it is here today, and then later driven to this court for another attendance of court in the matter that I have appeared this morning. Your Worship, for several times we did have make applications for bail because I would really want to have an end to it. I know I am innocent. As the light comes in, I am innocent and it will come to pass. But what is baffling is that on the 12th, when this matter was dismissed, I was driven still without knowledge, without notice, in a formula of kangaroo systems and jungle countries, and brought to this court. Still on my insistence and character, I was not brought before anybody. I guess probably it would have been you then, or there has not been a change of pattern as it always. Your Worship, this is psychologically torture. That somebody is being persecuted, first of all, abducted from court, then the prosecution, because with due respect, he is still the state. They go onto a fishing expedition, get into the lake, throw me at any jail they want, and bring me at any court at any time they want, at the detriment of my own rights. Your Worship is very psychologically torturing. My brain is telling me a matter. If you have a child of my stature that you school, and for the conviction of what he believes in is treated with this character, Your Worship is very torturing psychologically to my people, to myself, and I'm a husband with a sick wife, children going to school, but then court is being used as a tool of persecution. Because I don't mind the legality. Your Worship, I've reached an extent now of asking court if I'm not due Uganda to convict me and keep me for the time they want to keep me, rather than persecuting me court to court to court because of a democratic right that I have to speak for the National Unity Platform, a party in Uganda's constitution. I speak about the National Unity Platform because the case is being quoted as having happened at a legally established entity in this country. The reason I decided, Your Worship, to speak to you.
Interject that at this point you cannot go into your defense.
I'm not defending myself, and the lawyers will do it. But I wanted to be the human being I am and to speak to you, given the pattern of what has been happening to me. First of all, me being abducted from court premises. Your Worship, these things when I was in school I read about, they happened during a mean time. It is now happening now. And it is happening to us who are alive. As I conclude, I don't know my fate, whether it is in your hands, whether it is in the hands of some powerful individuals, but there is a song of the late Muwonge. It was about AIDS, but I want to use it today because this looks like AIDS. Today is me. Today, no, I'm not going to sing. I'm quoting from the song. Today is me. Tomorrow is somebody else. This country is a globe. Let me be persecuted for what I believe in. Let the enablers do it. But at one time, it will be their business to remember that they persecuted an innocent man, that they persecuted the person who was standing for the rights of others, that they persecuted the person who did not have to go through this.
Okay.
A father,
Waiswa,
as I conclude,
please.
because I am finishing, Your Worship. I've been at this for more than 7 months. I don't think 2 minutes will be too much. Your Worship, I've appeared before and I've given you
In this case, in this context, so let's.
and I don't know how many more will appear. But in conclusion, Your Worship, we will pray for Uganda. We will pray for court. We will pray for you. One day, we will be vindicated. I so submit.
Thank you.
Okay, now that I have heard from council, I have also heard from this person's appeal to the court. Of course, that 28 mandates me to hear from the state.
Much obliged. Your Worship, the appeal council have raised that issue. And brought up matters that which as court as part of the churches. Your Worship, in light of these issues, I pray that God gives me strength to get acquainted with, if any, the previous proceedings that happened, and then address court and respond to council's submissions. So pray.
Your Worship, I'm declining to
You are?
declining.
I thought you were to be with the court.
I'm opposing, I'm opposing this prayer for Israel. Your Worship, would like to automatically sign his warrant back to prison over this said charge we are saying it is not properly before this court. I humbly pray that this court pronounces it so on the facts which have been, facts and law which have been laid before court, to avoid more proceedings in maturing of your worship. So pray. We were given 10 budget in the previous.
We begin with you because you are the most senior.
There is the prayer from one of the okay, the clinical active person. He has informed me to that his visitation date, and since it is coming late, he is asking court to maybe to ask the officers to allow him to talk to the father one-on-one, since by the time they reach there, they will be past time, this second time.
I think that's a fair consideration since he's here and they are also here. Please don't please afford him some time to explain matters.
Yes.
Era hano wamulekedde ate agenze njagala nkwatireko wano ndabe bali abantu kati otunuzeeyo kamera ekole
yona simu njazikwadde mufaayo mwamba bukulembeze mulete baloya boogere tujjekola bansibye emagulu n'emikono Meya Nasana municipality bambadde obwamawulire Meya Nasana municipality gyayogereko eri eggwanga nze akikutte kanso yakutteyo wemba kanso yakutteyo nzooka kutereeza bange obadde ki
olina okuyiga nange kanso oliwulira naye mbawadde katiipa ako anti kati
kyogeddeokwattemuwa ne mukulembeze nolabikira mumawulire
bakuba ate yali akaaba tewali mawulire avuge yayigira musawo
nono wuno
maze ate wadeyagala
anti alina okumbuuza
kanso gyalongooddeko ekibadde mu kkooti okusingira ddala ono gwe bakyaginze mu fumbiro omusango gwe bamukyagingako enakawa
yes tandike
mu luganda tandike
sero nkumafalu kato kakulu leo tuli ku kkooti wano batubadde kukono ekanyanya nga tubadde n'emisango egya Eddie Mutwe n'abalala egyasoseewo naye oluvannyuma nga kkooti ewedde baleese Waiswa mufumbiro ogwokubiri bamusomera omusango gwe bamusomera edda nakawa era ne gugobwa twalwaizinga ensonga z'amateeka nti fayiro yali eriyo mu bumenyi bw'amateeka omulamuzi nakkizanya naffe naye kyatuukibwako yakwatibwa nga wa 9 nga 6 naye bamuta 12 guno omwezi ogwokubiri 2026 nga amaze okusavinga almost so badduse twategeezebwa nti olwennyini nga kkooti emaze okugoba omusango enakawa aba prison bamuvuga ekiro ne bamuleta mu kooti eno ye n'agaana actually sawa nga zigenda owere ekiro ye n'agaana okukola ki ova mu mmotoka n'agamba abalooya bange babadde nakawa tumubagambye nti mundeeta wano mubakubira amasimu bajje babeerewo n'olwekyo kyayambako nti baawuliriza nga tebasobola mutwalayo by force n'abalamuzi baali bagenze so olwaleero bakikoze bamusomedde omusango gwennyini ogwagobwa ennakawa era ne tulambika ensonga mu mateeka nti omusango gwagobeddwa ennakawa aye omusango gwe gumu gwennyini tegusobola kuleetebwa wano kubanga mu mateeka bwebanga nti kooti eri yentransfarinze omusango ate nga kooti eri teyalina buyinza mu mateeka wetula jurisdiction kuwuliriza musango therefore tesobola ate kusindika oba kwasayininga musango okubanga guwozesebwa wano mu kooti eno kubanga tosobola kugaba kyotalina mukitegedde so tugambye chief magistrate weno kooti nti alemegwa mu katego ak'omukuwozesa omusango gwennyini kyagishiti yennyini bakyusiza just mutwe gwa kooti ebeere wano so mu mateeka eyo eba disguised assignment over charge sheet ekitakkirizibwa tosobola kwasayininga jurisdiction wakiri singa babadde bagezi okusinga kawanadde bamwongerako emisango emirala charge sheet n'ekyuka naye bamaintaininze eki charge sheet yennyini so tetuwakanyiza ne tumuwa amateeka ne tugamba omulamuzi nti prosecution oba DPP eremereddwa mu kawaayiro ka 12 kuba etteeka limugamba okugulawo emisango mu kooti ezirina obuyinza naye bwe kibanga basobola okugulawo omusango ku Waiswa ennakawa kooti etalina buyinza kitegeeza eba eremereddwa mu ddute yaayo ssemateeka gwegiwa so z'ensonga zetugambye kooti negamba ejja kusalawo ewadde omwami wa gavumenti obudde agende yetegereza ensonga zaffe alabe oba akkirizaganya naffe oba takkiriziganya then ajayogereko then nakuza 13 yakomawo wano kooti etuwe ensala yaayo kuba tusabye judge sheet yeegobwe kubanga emenya amateeka
katukwase kato
buno uyo
wanji nva kwogerako omusibe mugumu omusibe ngera bwayogedde mu kooti mukiraba baali tebeetegese bakola ebintu nga bina bya persecution naye nga omulamu aguli nti tulina okutambula paka gyetulina okulaga era nga bwayogedde okwogerera ekibiina kya National Unity Platform tebwanko omusango because it is a legal entity and byonna era bye bakola obiraba tosobola kubanga omuntu omukute emyezi 7 ne mugoba omusango ogwo mwenna nga mukimanyi nti no mwali mukoze ensobi ne bayitawo emyezi 7 agisavinze asabye ebbeere omugimumye asabye buli kimu mukimumye omusango ne mugugoba ati ne mulaba nti tekirina kyekigasa era ne mukwatayo obudde obutali bwawala ne muleeta mu kooti endala ekooti gy'abadde ajjamu nno wano buli lunaku ku musango mulala kitegeeza nti bino ebintu babikola kagenderere kulumya kutokyalinga naye nga bwagambye today is me tomorrow is somebody else tulina okubeera nga tuli bagumu ate n'okuyiga n'okumanya byonna ebigenda mu maaso okuwanga Uganda mwebale.
Alright, mwebale nnyo mwena obwedda batuninze ino okuva gye twatandikidde paka wano wetuli ensonga ndowoozo zigoberedde bulungi z'Abaganda baffe bali makomera naye onjogere nnyangu ndowoozo olaba abo bali mu kutumaalira obumalizi obudde otunulira court session eno okuva gye yatandikidde paka wano weesembedde nga just bali mu kwogera luzungu olutalina kyerugasa muntu wa wansi mbw ate simanyi bannamawulire ate simanyi nti balina capturinga bigenda maaso mu kooti nti ate ono n'avaayo n'agamba nti bannamawulire beetaagisa nti ate simanyi families ez'abantu be bakwata balina okumanya ebigenda mu maaso nti ate bannamawulire aba live streaminga tetugenda bakkiriza ate bannamawulire tugenda bakkiriza ono nolabira ddala nga bintu bya kisiru ebitalina kye bitugasa naye kisingira ddala okunyiiza ye fakita nti Baganda baffe bano tebalina musango nagumu gwe bazza gwe tewali kisinga kuluma ng'ekyo ng'oli mu kkomera nga owulidde Waiswa ayogera ate ayogera n'obusungu ng'ayina obulumi ku mutima, ng'ali very frustrated, ali very angry, ali very, tewali kintu kirumanga ekyo okusiba nga tolina musango nagumu gw'okoze. Baabo bambi badde babaleeta this wano. Then the other thing olusewo ekiruma kwe kubeera nti oze mu kooti kale ng'osuubira nti togenda kuddayo mu kkomera, ne weesanga ng'olengera banno bali wabweru naye nga mmwe ate bali mu bakola ki, bali mu bazzaayo mu kkomera, n'olengera abaana bo abadde bazze okukyalirako, n'olengera mukyalawo kati ng'owa Shafiiki, n'olengera baganda bo, n'owulira ennaku ku mutima. Tewali kintu kinumanga ekyo. Kyolanga nsiba mbagamba mwena mwena abadde awo ne muddawo busimanyi nti mpeddemu amaanyi, busimanyi bannange ki ekigenda maaso and all that. Just think about these our comrades abali mu makomera nga tewali musango nagumu gwe yazza wabula because of standing for the truth. Nenga mwebale nnyo mwena obwedda abatuninze in mbalabe beda mukwe muli okuva gye twatandikidde, nange sigenda sukako wano badde wano essaawa nnya nnamba nga nange kamba komyo wano, sigenda sukako wano, tujja kuddamu later on. Bagenda komoyi na kuzo zigenda kubanga 13 mu kooti, bona nga babadde wa Eddie Mutwe, Olivia Lutaya, Sauda Madada, Achirewo Kivumbi, Bobi Giant, Shafiiki n'abalala bangi. These are just actual faces of the political prisoners, if I'm to mention. Because when you mention people like maybe Atalimu in this group, ye Machete. Yes. Ye Machete. Kuba yali ku fayiro ndala, tali ku fayiro yemu, ne bano baganda baffe. Ya fayiro ye ndala.
Kalunga luwete, tuliyambale ngule, tulizimba Uganda. Tuliyambale ngule, tulizimba Uganda. Tuliyambale ngule, tulizimba Uganda. Tuliyambale ngule, tulizimba Uganda. tuyambale ngwe tulizimba Uganda.